So another Second Amendment case which challenges the state of California's ban on so-called large capacity magazines is on the move once again. So let's talk about this. But real quick before we jump into this video, if you think the state of California's ban on so-called large capacity magazines clearly violates the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we will be discussing a Second Amendment case that is now moving forward, which challenges the state of California's ban on so-called large capacity magazines, or essentially any magazine that holds more than 10 rounds. The case we're going to be talking about in this video is titled Weiss v. Bonta, and it's similar in nature to another case that we've discussed, which is the Duncan v. Bonta California magazine ban case, or the Freedom Week case as many people refer to it as. This case, Weiss, was filed in the Eastern District of California, actually in the federal court in Fresno, which is around my neighborhood, whereas the Duncan case was filed in the Southern District of California, and as many people know, that is before Roger T. Benitez, or St. Benitez as he's known in California. Weiss v. Bonta involves the possession and purchase of so-called large capacity magazines in the state of California. Under California Penal Code Section 32310, that penal code bans the buying, selling, and possession of magazines that hold more than 10 rounds, or as California defines them to be so-called large capacity magazines. This law also includes a ban on 10-round grandfathered magazines that prior were determined to be illegal and were grandfathered in, and your possession of them was grandfathered in, but then the law was later changed, and also it was changed to retrospectively ban the possession of those grandfathered magazines as well. So this case, like Duncan, challenges the California confiscatory ban on all magazines that hold more than 10 rounds. Now, just so you know how absolutely insane the legal process is sometimes, this case Weiss was originally filed back in 2017 and has been stayed since 2019 because of Judge Benitez and his ruling in Duncan. This case, Weiss, was stayed, was put on hold while Duncan was making its way through the process at the Ninth Circuit level. For those not aware, in the Duncan v. Bonta case, District Court Judge Roger T. Benitez issued a ruling that found that California's magazine law was indeed a violation of the Second Amendment. In fact, what he did is he granted a motion for summary judgment in favor of the plaintiffs in that case, and also issued a permanent injunction which prevented the state of California and the law enforcement in the state from going after people in possession of magazines that hold more than 10 rounds. Of course, the state of California didn't like that they lost that case at the district court level, so they decided to appeal that decision up to the Ninth Circuit. Because of that, Judge Benitez also issued a stay on part of his judgment, but left in part the effect of his decision, which protected those who purchased Freedom Week magazines and also those who had still possession of grandfathered magazines that they had in their possession because it was prior lawful. Then Duncan made its way up to the Ninth Circuit, where a 3-judge panel upheld the decision of Judge Benitez. Then the en banc panel was seeking review, and an en banc review was sought, and ultimately the en banc panel in the Ninth Circuit ended up siding with the state of California. In coming to its decision, the Ninth Circuit en banc panel rejected text, history, and tradition as the type of test that they should use, and instead they continued to use their defunct now two-step approach, which relied heavily on intermediate scrutiny. Historically, the Ninth Circuit has used what is known as that two-step approach. In this type of analysis, the court first asks if the challenged law affects conduct that is protected by the Second Amendment. If it does, then the court moves to step 2 to determine what level of scrutiny should they apply. The en banc panel agreed that magazines implicate the Second Amendment, which meant that they qualified under that first step. Then they moved over to the second step to determine what level of scrutiny should be applied to this ban on so-called large capacity magazines. At this step, the Ninth Circuit en banc panel applied what is known as intermediate scrutiny. When a court uses intermediate scrutiny, that always essentially leads to the state gun control law being found constitutional, and that's exactly what ended up happening in this case, because simply if the state put forward some sort of public interest, the courts would always defer to that stated public interest. So oftentimes they would say that you need to limit magazines because it leads to more casualties. So courts like the Ninth Circuit have always kind of leaned in favor of that claimed public interest and upheld these types of restrictions. Now, even in that en banc decision, it wasn't as if all the judges agreed with using intermediate scrutiny. In fact, the dissent in that en banc panel decision said that they should use text, history, and tradition, and that this type of ban should be struck down. Now, after that en banc decision, the case Duncan was then elevated to the Supreme Court for their review. After the Supreme Court ruled in New York State Rifle and Pistol Association v. Bruin, the court then granted, vacated, and remanded the Duncan case back down to the Ninth Circuit en banc panel for them to reconsider their decision in light of Bruin. This was because the Supreme Court expressly rejected the two-step approach, and they also rejected tiered-based scrutiny in these types of Second Amendment cases. Instead, the Supreme Court reaffirmed that text as informed by relevant history and tradition is the type of analysis that must be used in these cases. Because of that decision in Bruin, the Ninth Circuit's prior analysis and decision in Duncan is now 100% void, and ultimately the Duncan case was then remanded back down to Judge Benitez for him to redecide this case using Bruin. Once Benitez got control of the Duncan case again, he continued the preliminary injunction protection on grandfathered magazines and Freedom Week magazines as well. So for those concerned about that protection of your grandfathered magazines and those Freedom Week magazines that you purchased during that Freedom Week period are still protected. He also set this case Duncan to be resolved as soon as possible, and it's set to be ended by this year. But currently the state of California is trying to push the Duncan case out into next year and is trying to delay that case as long as possible. But because of the Supreme Court's Bruin decision, and because the Ninth Circuit remanded the Duncan case back down to Judge Benitez, this second case that we're talking about, Weiss v. Bonta, is now coming out of its essential carbon freeze and is now once again proceeding forward. The order of the court reads, the court previously stayed this case pending defendant's appeal in Duncan v. Bonta. The parties have now filed a joint status report informing the court of the Supreme Court's decision granting certiorari in Duncan, vacating the judgment, and remanding it to the Ninth Circuit for further reconsideration in light of the court's decision in Bruin. Their joint status report also informed the court that the Ninth Circuit remanded the Duncan case to the district court for further proceedings consistent with Bruin. In light of these developments, the stay in this case is hereby lifted, and a status conference is set in this case for January 17th, 2023. So the court has now lifted the stay in this case. It's been on hold essentially kind of since 2019, but this is a case that started back in 2017, similar to Duncan. They've been going for a while, but finally this case is proceeding forward once again, and a conference is set for January. Now this case, Weiss, procedurally is significantly behind where the Duncan case currently is. Remember, Duncan has had a summary judgment ruling. It's been ruled on prior at a summary judgment level, and there's been a ton of development of the record at the Ninth Circuit level before the three-judge panel, before the en banc panel, briefs that were filed at the Supreme Court. So there's a lot more of the record developed in the Duncan case than there is in this case, Weiss. However, it's still a good thing to have multiple cases kind of in the queue and ready to attack the same law, but simply filed in different jurisdictions. So remember, the Duncan case is filed in the Southern District of California, and this case is in the Eastern District, and I believe it's in a Fresno federal court. So I just wanted to bring this other Second Amendment case that's challenging the California magazine ban back onto everybody's radar, back to everyone's attention, because as this case develops, it will kind of be trailing the Duncan case. And similar to how you have the Rupp case currently right now that was remanded back down, and that will be trailing the Miller case, and the Rupp and Miller case deal with California's ban on so-called assault weapons. So it's always good when you have multiple cases going on because you get more opportunities to strike down these unconstitutional laws. So if you guys have any questions, go ahead and comment down below, and I'll try to answer best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.